Well, the lawyer is going to tell you whether you have a claim that's worth pursuing in court, and in order to do so, the lawyer has to distinguish between latent and patent defects. A latent defect is a problem with your property that you shouldn't be able to discover upon a reasonable inspection of the property. So, for instance, if your wall is all rotted out, you wouldn't be able to see that upon a visual inspection of the property. And ordinarily, you would have a third-party inspector inspect the property before purchasing it. Well, they're not going to take the wall apart. So a latent defect is one that you're not reasonably expected to discover. A patent defect, on the other hand, is a defect that you should be able to discover upon a reasonable inspection of the property. An example would be a hole in the wall. I mean, you can see the hole, and you're presumed to take hold of the property knowing about the hole. So you take responsibility for patent defects. If you have a latent defect, you may be able to commence a claim in court to pursue and recover damages with respect to the property. So using again the example of an infestation in your wall, say it costs $20,000 to remediate that problem. You may then be able to launch a claim in court to recover that cost. Well, if the lawyer's interpretation is that the defect is a patent defect, the lawyer will advise you against commencing an action in court because of the principle of caveat emptor, which means buyer beware. Essentially, you take the property knowing of the risk and therefore take responsibility for it. You should contact your lawyer for expert advice, and you should do so sooner than later because there may be an issue with respect to the Limitation Act, which affects whether you are able to bring a claim. So my advice would be to contact your lawyer immediately.